Go back to speaking about how to navigate the treacherous waters of the court while remaining in honor. First off, it's important to know to reserve all your rights. Reserving all my rights, waiving none. All right? There are no facts in dispute. I waive all benefits without God. I'm just here to, as a man, to remain in honor. And they'll say something along the lines of, well, this is the state versus Derek S. Gonzalez. Are you Derek S. Gonzalez? We'll have a signed plea of guilty here today. Before we go any further, I have some questions I need clarified. And that's one tactic to remain in honor, okay? You're showing that you have intent to enter a plea of guilty, but before you can do so, you have some questions that need answered, all right? This is called a meeting of the minds, a sending of the mind. And one of the first questions I would ask is, who's the real party of interest invoking the jurisdiction of this court? Where is the claimant? Is the claimant here today? What time will the claimant be here? Is this court going to issue an arrest warrant for the claimant not being here, wasting this court's time? Yes or no? And wasting my time? Yes or no? They might try and drag you back into the name game. Are you Derek S. Gonzalez? Again, I have a signed plea of guilty here today. I just have a few questions that need to be answered for and on the official record. Is the claimant here today stating that I've done them harm, loss, or a wrong? Yes or no? These are yes or no questions. They don't need explanations. It's just yes or no. Who do these charges apply to? Can the claimant point to the man or woman today before this court that the charges apply to? Yes or no? You see, putting them in that position where you're exposing the fraud that they're engaged in. If the judge continues to help the prosecutor, now they're conspiring against your unalienable rights. Both of them are, okay? Through tricks and coercion, they're trying to induce you into fraud by way of inducement, all right? Fraud by way of enticement. They're trying to get you to claim something that you rightfully don't own. Does this court have a verified, sworn to pleading under the pains and penalties of perjury from the claimant? Yes or no? Well, the court has an affidavit of probable cause from an officer. Is that officer my accuser? Yes or no? No, the officer is just a witness. Okay, again, is the claimant before this court today? Yes or no? Well, the claimant's not here today, but the claimant is being represented by the prosecutor. The claimant is the state. When's the last time you spoke to the claimant? I need a date and a time. They're going to look at each other like idiots because they're caught. They're caught red-handed with their hand in the cookie jar, ladies and gentlemen. All right? The judge is in a precarious situation here. He's about to risk his entire career trying to figure out whether or not they can get you. And he's not about to do that. On average, most county court judges are netting anywhere from $160,000 to $275,000 a year, not to mention all the extra benefits and perks through their Baratray system. Okay? All the grant money they're getting for every conviction, for everybody that goes in there and pledges themselves as surety. All right? Nobody can answer when the last time is they talked to the state, because the state is no more real than Kris Kringle, the Easter Bunny, and the Tooth Fairy, ladies and gentlemen. So that means the man sitting across from you, alleging to be the representator or the representer of the state, is actually the man or woman bringing a claim against you under the guise that he has a claimant that has hired him to do so. The issue with that is, where is his warrant of attorney to represent his client? Does he have it for and on the official record before this court today? I see no facts and evidence to the contrary and believe none exist. Now, we want to try and stay away from controversy and making statements. So we ask the question, simply, where is the contract between you and the claimant? Where is your warrant of attorney to operate outside of Washington, D.C.? Do you have it? Yes or no? If you say yes, when will you bring it before this court so I may inspect it? What date, what time are you going to bring that document forward? And furthermore, when you bring that document forward, will your claimant be with you? Now people go, well, Derek, you ask a series of questions that the judge is going to get mad about. Sure. Sure, he or she's going to get pissed off. They want to see if you're going to stick to your guns. They're going to see if you're going to be with conviction or if you're going to fall to threats and duress. Because we're under military occupation and they're administering a bankruptcy, ladies and gentlemen. This is how these cretins get paid to do nothing. While you hard-working Americans have calluses and sweat dripping from your brow from the physical labor that you do every day after learning a series of skills that is productive, these people make a fortune conning you out of your life source energy. And sure, they get pissed off. Just like when you accuse somebody of being a thief and you know damn good and well they were the only one in the house and that $100 bill was sitting on that table, now that $100 bill is missing and they're the only ones there. And then you bust out the video footage and what do? They get defensive. Oh, well, I just moved it. I didn't steal it. I didn't take it. I'm not engaged in theft. You can't prove anything. Then you show them the footage and they get all pissed off about it. When they get caught up in their game, they get mad. But you're always going to give the judge a way out. Because he will act honorably if you do this correctly. Your intent going into a courtroom is to help the court. My intent coming in as Amicus Curiae, friend of the court, and I believe it's pronounced Amicus Curiae, or Mackenzie, friend of the court, is to help expedite this court's position and not to waste its time today. I'm a man here to remain in honor, and I'm just here to settle this matter. I believe a mistake has been made. Where is the claimant? Is the claimant present today? If the claimant is not here today, I require this case be dismissed for want of prosecution, for lack of jurisdiction, because the claimant isn't here to invoke the court's jurisdiction, and a fiction cannot invoke the jurisdiction of this court, and thus there is no case before this court. Now, I'm willing to forgive everybody in here for their actions today. But if we move forward any further than this, everybody in here is going to be held personally liable for their actions, because everybody has now been duly informed that this court lacks jurisdiction because the claimant is not properly known. You see, before any case can move forward, everybody must be identified clearly, because you're risking your life in that room, in that court. And if nobody else is risking their life, then this is unfair. This is not law, and this is not justice at all. This is a fleecing. They are looking for a controversy to be made, because the only thing a ministerial administrator can rule on is a controversy. So I always go in there and say there are no facts in dispute. I waive all benefits without God. I retain all of my unalienable rights and waive none. Do I have the right to face my accuser? Yes or no? That's a sticky question for him. Well, of course you have a right to face your accuser. The witnesses will be here in the next court date. No. No. That's a trick to get you to consent. And I didn't ask to face the witnesses because the witnesses are nothing more than a bold-faced liar. They have nothing to offer the court but hearsay. If the prosecutor stands up and tries to articulate something to the court, shut them down. Trinsley versus Pagliaro. Anybody speaking in here needs to swear in. If they're not sworn in under oath, under the pains and penalties of perjury, everything they're saying is hearsay. Their statements are stricken from the record because they can offer nothing to this court that would allow this court to reach a declaratory judgment or a summary judgment, period. You may sit down. And please don't open your mouth again while I assist this court in rendering a proper decision. Because again, my only intent here today is to remain in honor and provide remedy to any man, woman, or child I've caused harm. So if that claimant will come forward, I'd be more than happy to do so. Absent a claimant, I require this case be dismissed for a frivolous claim for which relief cannot be granted. It's not very hard, ladies and gentlemen. Jurisdiction can be challenged at any time. Jurisdiction is not challenged the way the gurus tell you that it's challenged. Oh, I just go in there and plead equity. That doesn't work. All right? I just go in there and I just say I'm challenging jurisdiction and it must be established for and on the official record. That doesn't work either. You're not asking the right questions. You're not asking the right questions. Questions are how you defeat the presumption of jurisdiction. That is how you properly challenge jurisdiction. What color of eyes does the claimant have? What color of hair? Now people go, oh, now you're going down a rocky road. The judges, the lawyer's going to stand up and say, relevance? Well, the relevance is suits can only be brought forward in like kind. Well, are you or are you not Derek S. Gonzalez? Can one be the name? Who is the claimant making claim in here today that I am Derek S. Gonzalez? You see, I've been known to use that name. I've been known to respond to that name. But who is the owner of that name and liable for it? You see, the birth certificate is an indemnification certificate, a bailor-bailee relationship. It's where your immunity comes from. You wave that piece of paper around and go, yep, Derek S. Gonzalez, he says he's guiltier than shit. But that ain't me. I'm not the surety for that. No. And as much as I can release my beneficial interest in said document, being that I don't own it, I'd be more than happy to give this to the court so you can settle this matter. We've made it far too difficult. I've heard of this method before in the past, and it just didn't resonate with my mind. And of course, we all ascend at different times and at different levels, and some of us go through the school of hard knocks, and it's pretty painful. So if I can help you from going through and getting through the system without picking up the scars that I have left on me, I would love to do so. Again, I don't provide legal advice, because legal advice is the undoing of God's law, and I don't believe in doing that. So it's really simple. There's no controversy before the court so long as you don't make a claim. The court requires 2 claimants in order to have a controversy. But without the claimant that's invoking the jurisdiction of the court, guess what? You become a claimant. And now that you've made a claim, the onus of probandi, the burden of proof, falls upon you. Now they have jurisdiction. I'm here by special visitation because only apparitions appear. Spirits, souls, things of that nature, dead things appear. All right? Apparitions. But I'm here by special visitation because a man may visit this house and may visit that house and may visit this building and may visit that building, but he doesn't just appear out of nowhere. All right? You can send a PM, but I get a lot of them a day. I can't guarantee you that I'll get to it right away or anything like that. I do have a number of things going on today. I just make these short videos to kind of help you guys out along your journey. Who's the one making the claim that that speed limit sign applies to I? Who is it? You know, it's so funny because you ask agents and agency these questions and they go, well, the legislator. When can I speak to the claimant? When can I speak to the legislator? Well, the legislator is a body of politic. Oh, so it's a group of men that have decided this. What are their names? When did I enter into contract with them? When did they get jurisdiction over I, the living man? Where's the contractual nexus between me and them? It doesn't exist. Show me out of 350 million Americans where 51% of the populace agreed to be governed, because that's what a democracy is. Just show me. I don't see it. And even if there was 51%, it's still consent by the governed, ladies and gentlemen, and I don't consent. Show me the contract that I as a man entered into, giving you jurisdiction, applying the statutes, codes, city ordinances, rules, and regulations to I as a man, where I have been actively engaged in being employed by the federal government or the state government for any duration of time at all. You know, you can go to the FBI and you can ask them to do a background check on the estate and entity and see if it's ever been employed by the federal government or state government. And if you've never been employed by the federal government or state government, it will come back as no. There are no records that reflect that your entity, your estate, has ever been employed by the federal government or state government. Now, I know people that are in the military that have done this, and the FBI still comes back and says they have never filled an office for the federal government or the state government in any capacity, which are who the statutes, codes, rules, and regulations apply to. What he got on there, John, he can only claim one role in the hearing. I know what you're talking about, brother. You talk about an officer. He can either be a process server, a witness, right? You can't be both. I believe that's what John's talking about there. Yep. So again, the issue is remaining in honor. And it's tough because they will say things that will make you want to chew their ass, and they're looking for you to do it. They love Americans that have bravado, and they really like the ones that they can piss off to the point where they just start spewing shit at the mouth because they got you. At that point, your hostility leads you to be an enemy belligerent combatant making statements you can't prove, and bingo, we gotcha. Thank you for playing. You're the dumbest contestant on this show today. Step right up and enjoy being the surety while your ass sits as an asset in jail while the bonds and securities mature. Thank you for claiming something you can't rightfully prove you own. That's a fact. There's limited liability, which is corporations. They're limited in their liability because the liability is only as great as the assets that they hold. After their assets are gone, there's nothing. But with man, we have unlimited liability. You might ask yourself why that is. Because even if you're homeless, even if you have not a pot to piss in, you still have life. And life source energy is an asset. So you have unlimited liability. I have a rebuttal, but I'm presently preoccupied. Appreciate that. What if the claim person is a cop? Well, it's simple. Are you the one making a claim against I? No. Well, what are you doing? Who's making the claim? Well, the state's making the claim. I'm just the witness. So, if you're just a witness, when can I meet the claimant that I caused harm, damage, and loss to? Just a practical question. Because when you read the Constitution, ladies and gentlemen, understand this. The right to face your accuser is biblical. It's an unalienable right, ladies and gentlemen, to face the man or woman that is accusing you. That's huge. And how quickly we forget about it and walk away from it. It's why they don't teach civics in school. They do not want you guys to know this stuff. Because if you know this stuff, their game stops. It's over. They will leave you alone. There are plenty of fish to fleece in the sea. They don't want to deal with a man or a woman who's rational, logical, applies themselves, and knows how to ask questions and not make statements. I came in with the authentic birth certificate and told them I am the beneficiary and that under the pains and penalties of perjury, and asked the judge by his personal name, who is he? Well, it's important to know and identify everybody in the court because they carry liability for the scheme, the Ponzi scheme they're playing on all of you. Now, I'll tell you this. If you've actually hurt somebody and the accused is going to come in and testify against you, this stuff isn't really going to work for you. So, be good to your neighbors, be good to your friends, be good to your family, be good to strangers. Because ultimately, if you do cause harm to somebody and they come in and bring a claim against you, they will invoke the jurisdiction of the court. Even though the state is bringing the claim, if they're willing to testify, chances are they're going to get jurisdiction. But when it's an agent and agency bringing a claim against you, they don't have a leg to stand on. It's either ineffective service of process, which is denial of due process of law, or they're a witness. They can't be both. Are you the claimant? No, I'm not the claimant. I'm the witness. Okay. Well, if you're the witness, then can you explain the denial of due process of law with ineffective service of process or ineffective process of service? That right there is grounds for a dismissal. All right? Due process is huge because without due process, there is nothing. All you have is a bunch of pirates, scallywags, stealing from you, unjustly enriching themselves. So due process is huge. Another way that you can thwart these people off is by going in to the clerk of the court and asking to see the magistrate 3 times. It's important. It's part of due process of law. And what you're looking for is for the verified claim made by the claimant under the pains and penalties of perjury. It must be verified. See, everybody's like, oh, I want to see the affidavit of complaint. I want to see the affidavit of probable cause. I want to see the verified claim made by the claimant independently bonding this case, stating how, when, where, and why I caused them a harm. I want to know their name and their address so that I may resolve this on the private side so as not to waste this court's time. If remedy can be had outside this court, I would sure like an opportunity to do so. See, that's where when you come into court and there's actually a claimant and the judge realizes that due process hasn't been necessarily followed, you know what they'll do? You know, this court is going to grant a recess, and we're going to allow an hour mediation for you guys. There's a room just outside the hall. So as, you know, to avoid any controversy, we're going to give you guys an opportunity in the hall to entertain the idea of mediation. If you guys can't come to a firm understanding there, then we'll bring you back in here. Now, that may be at the part where the attorney tries to tell you, you know, if we go back in there, you know, I know the judge. I work here. I've seen what he does to guys like you. He's going to put you in a cage, right? That's false and misleading statements, ladies and gentlemen. That's threat, duress, and coercion. He's misleading you. Are you willing to put that down on an affidavit and sign your name to it? Well, of course not. I know you're not going to do that. You don't want to give me any more evidence than you've already given me. I get it. Plus, you can't speak for another man. You have no idea what that man's going to do. I know what he's going to do, only because you don't have a claimant. And because you don't have a claimant, you're a liable party for bringing fraud upon the court. Bar association member or not, doesn't make a damn bit of difference to me. You brought fraud into the court by not having a claimant, a real man or woman, and I'm going to nail your nuts to the wall. I can forgive you at this point if you just want to go back in there and make this all disappear with a piece of paper and retract and redact any record that you allegedly created that has a bunch of false and misleading statements that can't be verified by anybody. He did this, or he did that, or he did this, or he did that. Which is it? You see, the law acts specifically. That's why everything must be identified specifically. I can't say you punched my dog, or you kicked my dog, or you sprayed it with the hose. The judge is going to say, well, what did he do? You brought forward a claim for which relief cannot be granted. It's not specific enough, Derek. You need to be very specific about your poignant points of what transpired, and it needs to be verified. You may even consider doing a deposition because your affidavit is nothing more than hearsay until deposed or placed on what? The miscellaneous land record. A lot of people are saying, Derek, I'm filing documents into court cases and they're just throwing them out. Yeah, they can. You want to know why? Because you don't have it established on the public record. They don't have to view anything you file into that court case until it's on public record. Once it's on public record, and you can go down to the miscellaneous land record and ascertain a certified copy of it being publicly recorded, which is public notice, now they ain't throwing nothing out of the court. Promise you that. Because to tamper with a record in a court is a felony. They ain't going to do that. So establish your record properly by putting it on the miscellaneous land record, ascertaining a certified copy. To put something on the miscellaneous land record takes about 24 hours because they have to read through it, make sure everything's correct, and place it on the record. And they'll give you a call or send it to you by way of mail and tell you to come on up and pick up your certified copy. Go pay for the certified copy. I would suggest getting 3 of them. Send one to the prosecutor, one to the court, and keep one for yourself. Keith, what do you got there? 22 CFR 93.1 and 22 CFR 93.2. I don't have my computer in front of me, brother. Can one make a special appearance under threat, duress, and coercion, or do you have to pick one? Well, again, I would opt not to make a special appearance. That's a great question. I'm here by special visitation as a man who wishes to remain in honor to settle any matter before this court today. Is the claimant here today before this court with verified claim under the pains and penalties of perjury, stating that I've caused them harm, wrong, loss, or damage? Yes or no? Who is invoking the jurisdiction of this court? I'll call you back, brother. I see you calling. I'll call you back. What other questions are out there? Limited appearance by paper. Yep. Notice of suit or of default judgment. C. We got Keith. I love my brother Keith. He's always on the ball. Special visitation on whose behalf? I'll jump back on here a little bit later, guys. I've got something I'm putting together, and again, I do these videos to help people. This isn't legal advice or anything like that, but just think about it logically, all right, with sane, sound mind, all right? Think about what I'm telling you. The second you make a claim, you're the one who created controversy. Could it be, if you don't make a claim, there's no claimants before the court? Because the state is a fiction of man's imagination that exists only on paper. So could it be that by you going in there and claiming the name, you are the claimant now, and you just created controversy? Could it be? Thanks for joining me. I'll talk to you guys a little bit later today.